Good morning, Your Honour. Monica Fernandes, counselling appearing for the Crown. This morning I am going to seek an order on the competence and comparability of witnesses in the upcoming trial and on the admissibility of the CCTV evidence. Your Honour, to the question whether the accused Adam is competent to give evidence against Barbara, my submission is as follows. Under Section 9 of the Evidence Act, the presumption is that every person, including a child, is presumed to be competent. The common law position is that competence implies comparability. Everyone who is competent is prima facie compellable to give evidence, and the authority here is Hoskin and the Metropolitan Police Commissioner. As Adam and Barbara are also co-accused in the upcoming trial, that raises the competence issue as well. At common law, the case Payne provides a position that where two prisoners are tried together, one is not a competent witness for the other. Subsection 8, Section 1 of the Evidence Act provides that each person charged is competent to give evidence, regardless if they are charged jointly or individually. However, they're not compellable. Prima facie, Adam is competent to give evidence against Barbara, but he's not compellable. However, we also have another issue that Adam and Barbara are also married, which raises the issue, the Section 8, Subsection 2 of the Evidence Act, where it states that Adam is competent and compellable. In saying that, the status of the co-accused takes precedent, and the authority here is Callahan and Bush, and Adam will therefore remain competent but not compellable to give evidence. Your Honour, on the submission whether Michael is competent and compellable to give evidence against Barbara, my submission is as follows. As mentioned above, under Section 9 of the Evidence Act, the presumption is that every person is compelled is competent to give evidence. Michael is 5 years old, therefore he is presumed to be competent. However, due to being so young, this will raise the issue of Michael's competence. In that regard, under Section 9, capital A, under Section 9, capital A, we would have the test for competency. All persons, including children, are competent if they can give an intelligible account of the events they have observed and experienced. As Michael was hiding under the kitchen bench, he didn't see the events. Therefore, Michael will be giving a testimonial of what he's heard. We're not sure of what he actually observed, but we will seek expert advice under Section 9, capital C and capital E. If Michael is able to give an intelligible account of the events, therefore he is considered competent in this instance, then Michael is able to give a competent and a compellable and his compellable witness as well. Your Honour, to the question whether Jennifer is competent and compellable to give evidence against Barbara and Adam, my submission is as follows. As mentioned before, Section 9, the presumption is that every person, including a child, is presumed to be competent. Jennifer is 11 years old, therefore she is presumed to be competent. Prima facie, competent means you are also compellable. The issue we face here is Jennifer suffers from hearing loss. Therefore, we need to further decide if Jennifer's disability affects her competence, and therefore we would like to call an expert witness to assess Jennifer's competence. Section 131A allows the court to provide an interpreter, which we would like to request. However, the issue we face here is if the translation is not accurate, therefore then it would raise the issue of competence, and if not competent, then of course Jennifer would not be compelled. On the submission regarding the CCTV admissibility, we would like to seek a ruling to consider the CCTV evidence admissible in the upcoming trial, as the evidence is relevant to the proceedings. Your Honour, we understand that the evidence was unlawfully obtained, as Constable Jones did not have a search warrant and failed to comply with the relevant provisions in the Police Powers and Responsibilities Act. Your Honour, we submit that the CCTV evidence and its context should be admissible on the grounds that it might be considered relevant, and request the courts to not use its discretion to deem the evidence inadmissible on the public policy grounds. As per Barnes versus Cross, we submit that Constable Jones' conduct was not a deliberate breach of the law. We submit that the evidence is relevant and have the potential to rationally affect directly the assessment of the probability of the existence of a fact in issue. The CCTV evidence recorded directly the GBH caused on Jennifer, and this offence is a serious offence under the Criminal Code. If not obtained immediately, we also submit that the evidence stored on the smartphone could have been easily deleted or destroyed. So the police had to act fast to get the evidence. Your Honour, we further request that the court do not use its discretion to deem the evidence inadmissible on fairness grounds, and that the evidence should be admissible and not excluded under Section 130 of the Evidence Act, and the authority here is Hashler. We submit that in performing the balancing exercise, the probative effect far outweighs the prejudicial effect, as the evidence is direct proof of the offence. Your Honour, on that basis, we request that the evidence submitted is admissible to the upcoming trial. Thank you.